Good morning. Welcome to the Long Live Third Parties podcast. Free Press Media Press Inc., a third parties books publisher, sponsors this podcast. I'm Andrew Bouchard. Today I read the case Green Party versus Henrichs, 822NE2D910, Illinois Appellate Court, 3rd District, 2005. Friends, we're going to talk about the Green Party again because they put a lot of cases up like they should do. So let us find a way for the Green Party to inspire us. This ballot access case involves the state of Illinois. That's where I went to high school. I lived there for my high school years. Any of you out there from Illinois, shout out to Illinois people, especially if you're a member of a third party. Let me know what being a third party in Illinois is like. This ballot access case can inspire us, so let's read from the record. It says, quote, "In this case, from the Circuit Court of Iroquois County, the plaintiffs Green Party and two Green Party candidates, Dale Strow and Ginger Searle, appeal from a denial of their motion to be placed on the ballot in the general election on November 2nd, 2004 for two county-wide positions in Iroquois County. On June 21st, 2004, Straw filed a nominating petition on behalf of the Green Party, nominating three candidates for three county-wide positions in Iroquois County. On June 28, 2004, defendant James Spielman filed an objection to the petition, alleging a violation of election code 10 ILCS 5-1.1 ET SEQ West 2002. Because the petition did not nominate candidates for 13 other county board positions open for election in 2004. On August 16, 2004, the Circuit Court rendered a decision finding the petition was insufficient and therefore invalid and removed the Green Party candidates from the ballot. The plaintiffs appealed." End quote. Have you heard of any ballot access law like this before? This sounds strict to me. Every state I'm coming across in these cases has a different take on ballot access laws. In this case, it states how Illinois requires them in that county to file for every open position. That's hard to meet. If I'm not mistaken, I remember sometimes the two parties don't file candidates in every position. But they say here that's different because the two parties are already established and they already have done enough stuff to show that they have a backing, whereas the third parties don't. What do you think about that, friends? They also state here, our friends at the Green Party argued this violated, quote, Illinois freedom of speech and assembly, due process, and equal protection guarantees, end quote. As I've been noting again and again in these ballot access trials, they invoke the arguments of the First and 14th Amendments. We love that. We love the First Amendment here at Free Press Media Press Inc. And the 14th Amendment rocks too. In this case, they're not, at least from the record here, invoking the 14th Amendment and the First Amendment because that's a constitutional thing at the national level, but they are invoking the similar provisions from the Illinois Constitution. So bravo, friends, bravo. They do address how the states have a right to what they call burden, quote, burden the First and 14th Amendments rights, end quote. They say something I don't like here. They say, quote, "If a new party is not able to field candidates for each open position in a political district, that raises doubts as to whether the organization should even be considered a political party," end quote. And they also say, quote, "The requirement does not prevent any specific individual from running for office, since candidates may run as independents, end quote. So 13 districts, you have to have a candidate for each individual district. What if the area had 30 districts? You have to have 30 candidates? That's a high standard to meet. I'm not liking this. I take it you don't like it either. They have a section they call Prohibition Party. I'm not sure why they call it that, because in that section they don't reference the Prohibition Party. Right above it, they cite a case called Coalition for Free and Open Elections versus McElderry, which we discussed on this podcast. That did involve the Prohibition Party. But I'm not sure why they're laying it out in such a way. You have to read between the lines to see why they're mentioning the Prohibition Party. So friends, what do you think happened ultimately here? It says, quote, the trial court rightly found that the plain language of the election code requires that a new political party field candidates for all open positions in the political district in which it seeks to be recognized as a party. In addition, we find the constitutional arguments of the plaintiffs do not warrant a different result. We therefore affirm the order of the Circuit Court of Iroquois County rejecting the petition, end quote. Friends, what do you think about that? I don't like that. That law sucks. I never heard of anything like that before. And hopefully we won't hear about it again. But I'm sure we'll see more of the same as we come across these other cases in other states and their versions of ballot access laws. So bravo to the Green Party of Illinois for fighting the good fight, and let us do what we can in our capacity to fight for the good fight too. Long live third parties. Goodbye.